all our viewers, welcome back to another What If video. My name is Viapia, and as always, it is fantastic to have you. Today's topic, another interesting one, is what if an employee hands in a medical certificate from a traditional health practitioner? This has been an ongoing debate, and the debate being whether or not an employer should accept a traditional or a certificate at least from a traditional health practitioner as proof of incapacity. Now, in unpacking this topic, we first need to look at the relevant legislation. Relevant legislation being first and foremost the basic Conditions of Employment Act. Now, Section 23 of the BCA sets out the requirements for a medical certificate to be valid for the purposes of the BCA. What are these requirements? One, the traditional health practitioner needs to be certified to diagnose and treat. The second requirement being is that this certification process to diagnose and treat must be as a result of an act of Parliament. Now, an employer is obviously entitled to request the employee to submit a valid medical certificate, if we look at the wording of Section 23, and you will not be required to pay an employee if the employee is not able to comply, or at least the medical certificate is non-compliant. We know that in terms of Rule 16 of the Health Professions Council Ethical Rules of Conduct, it prescribes the information that needs to be contained on the medical certificate for it to be valid. However, that does not necessarily apply to the traditional health practitioner's certificate, but more about that in a minute. Some background: in 2014, the President signed the Traditional Health Practitioners Act, or the THPA. The THPA provides primarily for the registration of traditional health practitioners. So if we apply the requirements as set out in Section 23, it appears as if the statutory requirements, at least of the BCA, have been met. 2011, our Minister of Health, at least back then, also issued regulations in terms of the THPA, and these regulations, amongst other things, established the Interim Traditional Health Practitioners Council, which drives the implementation of the THPA. Amongst other things, again, the council is responsible for the registration of traditional healers or practitioners, etc. Now, Section 21 of the Traditional Health Practitioners Act, or the THPA, also sets up the application procedure for the practitioners, and it also provides that once registered, the practitioner will be issued with a certificate, and his or her name will be added to the register. The register being crucial for our discussion because, as far as we are concerned, the register at this point in time is non-existent, and that is why it is quite difficult to establish whether a traditional health practitioner is registered. Over and above this, at this point in time, the council has no website. Consequently, it is not possible to easily ascertain whether the practitioner has been registered in terms of the Act. Also, the Minister of Health has to date not published the register that I referred to, or any supplementary list of registered traditional health practitioners as contemplated in the Act. So consequently, the onus, at this point in time at least, would be on the traditional health practitioner to prove to his patient, or obviously an inquiring employer, as to whether or not he is registered in accordance with the Act. And until such a time that the register or any supplementary list of registered traditional health practitioners have been published, it will likely be a challenge, as we all know. So, as it stands, any traditional health practitioner's medical certificate issued by this practitioner who is registered with the council would be deemed to be valid. At this stage also, employers would be obligated to accept a traditional health practitioner's medical certificate if it is issued by a registered traditional health practitioner. Now, in terms of its content, the certificate must be valid in respect of content. If we look at a medical certificate issued by any other medical professional or doctor. As I've mentioned earlier, Rule 16 of the HPCSA's Ethical Rules of Conduct applies, and it, like I said, contains a guideline or guidelines relating to what the medical certificate, what information the medical certificate must contain. However, the PHPA, the Traditional Health Practitioners Act, is silent with regards to the content and or requirements of a valid medical certificate from the traditional health practitioner. This in itself is another challenge. In addition to this, there's no regulations have been made or promulgated by the Minister of Health to provide any further guidance in this regard. In other words, guidance in respect of what information must, or what content, what information must be on the medical certificate. In our opinion, or at least in our view, in the absence of these guidelines regarding the technical requirements for the medical certificate, consider it as a valid certificate by the council, the system is open to abuse, and there will be the issuing of non-compliant documents. However, one would hope that once the register, as I've mentioned earlier, is published and the guidelines pertaining to the technical requirements for these practitioners' medical certificates are available, this may then be verified with the council if you have any doubt in respect or regarding its authenticity. As a result of this, it would be difficult at this point in time to determine the validity of a certificate, even if it's issued by a registered practitioner. Now, just in conclusion, if the traditional health practitioner is registered in accordance with the THPA, he or she is certified to diagnose and treat as per Section 23. We've mentioned that being the requirements as set out in the BCA. That certificate issued by the traditional health practitioner will be valid unless the certificate does not comply with the technical guidelines that is to be published by the council. As an employer who receives a medical certificate from a traditional health practitioner, you can request the employee to prove that the traditional health practitioner is registered in accordance with the THPA, or the certificate obviously confirms the same. You have the discretion, if the employee is not able to provide proof, to either convert the number of days that he or she was booked off sick to annual leave, or to treat those days on the basis of no work, no pay. In other words, what we are saying is that if there's a dispute about the authenticity or the validity of the certificate, you can ask the employee to prove to you that the traditional health practitioner is registered. If the employee cannot prove the same, you can treat those days as unpaid, the no work, no pay principle, or you can convert those days to annual leave. Now, the question whether the council will have the necessary capacity to be able to carry out this mandate, or its mandate that I've referred to, which includes, as I've mentioned, providing the structure for registration as well as the monitoring of traditional healers, this remains to be unseen. However, given the size of the traditional health sector, currently estimated over 200,000 practitioners, and the administrative challenges referred to, it seems very unlikely to take place, at least take place soon. Ladies and gentlemen, thank you again for joining me for this video. That brings me to the end. As always, please, if you have any queries in this regard, do not hesitate to contact us. Please head over to our main profile page, hit the like button, and even share this video with your friends and colleagues. We hope to publish another video in 2 weeks' time, but until next time, thank you for your time, and bye-bye.